Trump's Department of Justice asking a judge to release grand jury testimony in the Jeffrey Epstein case. This comes after members of Trump's base staged a mutiny over his attorney general's failure to release the so-called Epstein files. The move may temporarily quiet some of the MAGA uproar, but it's unclear what the grand jury transcript could actually reveal. It's not a complete record of the investigation, just enough to get an indictment. And the judge has to agree to release it, which could take time, potentially a long time. The DOJ is making the request as Trump filed a defamation suit against his old friend Rupert Murdoch. Trump is asking for at least $10 billion in damages against a guy that Trump spent years praising.
My very good friend, Rupert Murdoch. There's only one Rupert.
I even got a call from Rupert Murdoch, who I have a lot of respect for. The legendary Rupert Murdoch.
Hey friends, A-John is here, so let's get started. Trump sued the Wall Street Journal over their reporting about a birthday letter allegedly sent to Jeffrey Epstein, a note with strange language about enigmas who never age and keeping secrets. Trump denied it completely, suggested it was fabricated, and at one point floated the idea that a time traveler had planted it.
Trump taking this action after the Murdoch-owned Wall Street Journal published a letter to Jeffrey Epstein bearing Donald Trump's name, containing a drawing of a woman's body with breasts and a Donald signature in the place of pubic hair. The message reads in part, "Happy birthday, and may every day be another wonderful secret." Trump claims the letter is fake, saying in part, quote, "I don't draw pictures," although he did draw pictures that were auctioned off during his first term in office. Trump's closest allies, though, are coming to his defense. His vice president, who has been curiously silent on the Epstein saga after previously calling for the release of documents, posted on social media, quote, "Does anyone honestly believe this sounds like Donald Trump?" To be clear, he is talking about this Donald Trump.
The judge dismissed his complaint, not because the Journal won, but because Trump's filing didn't meet the legal threshold for defamation. It looks like a favor. It isn't. The dismissal was without prejudice, meaning Trump can refile. And if he does, he'll have to plead specific facts. Facts that will require discovery, sworn testimony, and a detailed accounting of exactly what his relationship with Jeffrey Epstein actually was.
Grab him by the I could do anything.
Evan Perez is out front in Washington. Evan, what does Attorney General Pam Bondi say in this new filing asking to release testimony in the Epstein case?
Well, Brianna, they're citing the public interest for asking a judge in Manhattan to release the testimony that was gathered as part of this investigation, these charges in 2019 against Jeffrey Epstein, sex trafficking and other charges, that is before he committed suicide in prison. This was a filing, it was just 4 pages that was filed with the signature of the Attorney General Pam Bondi and Todd Blanche, the Deputy Attorney General. I'll read you just a part of what it says. It says, "The public interest in the Epstein matter has remained. Given this long-standing and legitimate interest, the government now moves to unseal grand jury transcripts associated with Epstein." And it also goes on to cite.
Now, this is where the peculiar mechanics of federal civil procedure enter the picture and create the conditions for what may become one of the most politically explosive depositions in American legal history. When a court dismisses a complaint for the first time, unless there is some fundamental defect like an expired statute of limitations that cannot be cured by better pleading.
Brianna, another case in Florida, in the state of Florida, if you remember, he was prosecuted, or he got a plea deal in that case in the state of Florida. And in that case, the judge released some of the grand jury testimony there and said that the Epstein case, the facts around the Epstein case, tell a tale of national disgrace. Now, that is what the Justice Department cites as part of the reason why this information should be made public. We should note that traditionally grand jury secrecy governs all of this. It's not usually released, but judges are known to do so in the case of public interest. And this is something, of course, that's going to take some time, because judges typically want to also get the input of any victims, anybody who has been named in that testimony, whose privacy needs to be protected under federal law.
And Evan, also breaking tonight, Trump filing a lawsuit against the owner of the Wall Street Journal after the Journal's story about a letter that is signed by Donald to Epstein. What can you tell us about that suit?
The judge will typically grant what is called leave to amend. The rules specifically instruct that leave to amend should be freely given, meaning judges are supposed to err on the side of allowing litigants at least one opportunity to fix whatever deficiencies caused their initial complaint to fail. The theory behind this liberal amendment policy is entirely sensible in the abstract. Courts do not want to throw out potentially meritorious cases simply because a lawyer missed a technical requirement.
Well, the president is now filing this lawsuit in the Southern District of Florida, in Miami, and it is citing both libel and slander as part of the reason for this action, and he's requesting, Brianna, $10 billion in damage plus additional punitive damages. He goes through, the lawsuit goes through about 20 pages, citing the Wall Street Journal not only publishing this information, despite the president talking to them and telling them that it was not his signature, it's not his message that was included in those letters, and also notes the wide circulation of this article in the Wall Street Journal. It is a lawsuit against Dow Jones and Company, against News Corporation, against the reporters who wrote that article, and against Rupert Murdoch himself. So we'll see whether this goes forward. You remember, of course, yesterday the president posted on social media that he can't wait for Rupert Murdoch to be deposed in that case. Of course, as you know, in a civil lawsuit like this, the president himself will open himself up to some of that treatment in court, because his association with Epstein will become part of that case as well.
Or failed to articulate certain elements with perfect precision. If the underlying claim has substance, the system wants to give it a chance to be properly presented. But some litigants have learned to exploit this procedural generosity for strategic purposes that have nothing to do with pursuing justice. Donald Trump is the master of this particular dark art. The playbook is well established and has been deployed across dozens of cases spanning his entire business and political career.
Yeah. Evan Perez, thank you so much for that great reporting. And out front now, Ryan Goodman, our Outfront legal analyst. We have former Fox News anchor Gretchen Carlson, and also Barry Levine, author of The Spider, Inside the Criminal Web of Jeffrey Epstein and Ghislaine Maxwell. Ryan, DOJ just asking a federal judge to make this public, this grand jury testimony in the Epstein case. When, and if this judge releases this, will the public learn anything potentially useful?
So it's first an uphill battle to get a judge to release grand jury materials, especially because this doesn't really fit any of the statutory or regulatory reasons that a court would do that. The court would have to find that it has inherent powers. Very unusual. And then at the end of the day, I don't think it's the material that the public really wants. The public wants to know what other individuals were involved in sexual abuse of minors. It's probably not in these grand jury materials. The grand jury indictments, in fact, are very limited to Maxwell and Epstein's abuse of minors and do not mention other individuals. So there's every likelihood with those narrow indictments, they weren't even presented with that. I think the real material that the public wants is in the DOJ's offices. It's not what was presented to the grand jury.
Yeah, I see Gretchen and Barry, both of you nodding to that. So Barry, talk about some of that other information that would not be contained in grand jury testimony.
You file an initial complaint that is deliberately or carelessly deficient. You then request multiple extensions of time, dragging out the early stages of the litigation for months. When the court finally gets around to reviewing your pleading and dismisses it, you express outrage at the unfairness of the system while quietly filing your amended complaint. That amended version then works its way through the same slow machinery, facing new motions to dismiss and new rounds of briefing. By the time a court finally makes a definitive ruling on whether the case can proceed or must be dismissed with prejudice.
Of course, Brianna, the transparency is really what all of us want here. And there's over 100,000 pages of documents, of FBI files. And of course, as he was just saying, the grand jury testimony is really limited to what the indictment said was the period of time from 2002 to 2005 when Epstein abused women in Palm Beach at his mansion there and in New York. We're looking for the complete transparency of all the files so we can learn about the interviews that had been conducted over the years by the FBI. We can learn the details of the autopsy report after Jeffrey Epstein's death behind bars. I'm particularly interested in his primary accuser, Virginia Giuffre. She had named six or seven prominent individuals who she said she had been trafficked to. Did the FBI try to corroborate any evidence related to these men? Are there interviews with any of these men? Are there interviews with any associates? There has to be a great deal of information in those files that could help us understand the 2 decades of sexual abuse of more than 1,000 victims.
Gretchen, whatever is released, I mean, you would expect a lot would be redacted, from victims' names to accusers' names to people who may have been accused, but nothing at this point is founded, right? I mean, you can't just put the names out there.
12 to 18 months have elapsed since the initial filing. The public has moved on to other controversies. The headlines that accompanied the original lawsuit have faded from memory, and Trump has achieved his actual goal, which was never about winning in court, but about running out the clock until everyone stops paying attention. This is remarkably similar to his approach to international affairs. When confronted with a crisis or a negotiation, Trump simply drags things out indefinitely. He extends timelines, creates diversions.
In these legal filings of people accused, but it's not found. It's not, if it's potentially baseless, there's a problem there. So how is the part of Donald Trump's base that really wants to see this information going to be placated by seeing this stuff?
Yeah, I think that this raises a really important question about whether or not Trump putting out another potential fake news story is going to actually gin up the base again. Trump doesn't strategize about many things, but we saw this happening earlier this week. We know the Wall Street Journal reached out to him on Tuesday. By Wednesday, he was saying it was a hoax and that this was all up to the Democrats. So he was already preparing his base to not believe the story that was going to come out in the Wall Street Journal. Then you add into it that the story really wasn't this massive expose that some people were talking about. And so now you've had some of his influencers, like Laura Loomer, who has a lot of power, saying that it's fake news. So I tend to believe that this will work to coalesce the MAGA base to come back behind Trump. The interesting twist here could be if the judge denies the release of this grand jury information, then the base is going to say, why is Donald Trump and why is Pam Bondi not releasing the millions of other documents that they could release right now? So I think there's still a lot to be seen about what's going to happen, but I think the Wall Street Journal story has probably coalesced the MAGA base behind Donald Trump.
Generates new controversies that push old ones out of the news cycle. North Korea developed nuclear weapons and advanced ballistic missile capabilities because the issue simply faded from public attention as other dramas consumed the headlines. In litigation, the strategy operates on the same principle. Lose the cases, but lose them so slowly that by the time the loss arrives, nobody is still watching and nobody remembers what the fight was originally about. But here is where the trap begins to reveal itself, and it is a trap of Trump's own making, even though he seems entirely unaware that he has constructed it. As soon as the court dismissed his initial complaint against the Wall Street Journal, but granted him leave to amend, Trump immediately announced that he would refile the case. He is doubling down. He is pressing forward. He is walking directly into the very scenario that any competent lawyer would advise him to avoid at all costs. Because once Trump files his amended complaint, once he inserts the magic words about actual malice that were missing from his first attempt, he opens a door that cannot be closed. The Wall Street Journal, or more precisely their lawyers, will have the most basic and devastating tool available in civil litigation. They will ask for Donald Trump's deposition. This is where the conventional legal strategy of filing motions to dismiss becomes counterproductive, at least if the goal is to actually damage Trump rather than simply win a procedural victory. Most defendants who get sued by Trump understand that his cases are without merit. Their reflex is to attack the complaint on legal grounds, to argue that even accepting all of Trump's Trump's allegations as true, he still cannot satisfy the elements of his claim. This approach has its advantages. It resolves the case quickly without the expense and burden of discovery. It prevents Trump from using the litigation as a fishing expedition into his opponent's affairs. But it also spares Trump from the one thing he fears most in the legal system: being forced to sit in a room under oath with skilled attorneys asking him questions he cannot deflect with bluster or social media posts. If Trump ever filed a defamation lawsuit against someone who truly wanted to destroy him, the strategy would not be to file motions to dismiss. The strategy would be to answer the complaint, forego procedural objections, and say the words that terrify every litigation-savvy observer who understands Trump's vulnerabilities. Let's go to trial. Let's do it right now. Show up in front of a jury and explain your relationship with Jeffrey Epstein. Show up and tell them about the time traveler you claim forged that birthday card. Make this the most public examination of your connections to one of the most notorious figures in modern American history. Before trial even arrives, there is an even more immediate threat. Civil discovery includes the deposition, and a deposition is where Trump's entire mythology collapses under the weight of his own words. The scope of discovery in federal civil litigation is extraordinarily broad. The standard is not whether a question would produce admissible evidence at trial. The standard is whether the question is reasonably calculated to lead to the discovery of admissible evidence. When Trump sues someone over matters relating to Jeffrey Epstein, he opens the door to questions about every aspect of his relationship with Epstein, every statement he has made about Epstein over the years, every interaction that has been documented or reported, every connection that has ever been alleged. The deposition would not be a limited inquiry into whether Trump personally drew a specific birthday card. It would be a comprehensive examination of the entire history between these two men who moved in the same social circles for years. Trump's complaint itself makes the scope of permissible questioning even broader than it would otherwise be. His legal filing includes a footnote listing numerous articles that allegedly took their cues from the Wall Street Journal report and published their own allegations about Trump and Epstein. By putting those articles at issue in the litigation, Trump has made them fair game for discovery. The deposition would proceed methodically through each article, each allegation, each reported incident. The questions would be simple and devastating. This article says, Epstein described you as his wingman. Is that true or false? This report says you socialized together regularly at Mar-a-Lago. Is that true or false? This account describes conversations you had about certain parties. Is that true or false? Hour after hour, the entire sordid history would be unpacked in sworn testimony that would become part of the public record. The deposition would extend for 7 hours or more, the full day permitted under the federal rules, plus whatever additional time the court might grant given the breadth of relevant subject matter. Every minute would be focused on the Epstein relationship. Every question would be designed to pin Trump down on specifics he has spent years avoiding. Every answer would be subject to verification through documents, through other witnesses, through the extensive public record of his own statements over decades. Trump cannot survive this kind of sustained examination. His history with depositions demonstrates this conclusively. The depositions in the E. Jean Carroll cases were catastrophic. He contradicted himself repeatedly. He made statements that later proved to be demonstrably false. He displayed the kind of evasive, combative, and ultimately self-destructive behavior that skilled litigators dream of encountering in an opposing party. The depositions conducted by the New York Attorney General's office during Letitia James's investigation were equally disastrous. He took the Fifth Amendment hundreds of times. He struggled to answer basic questions without wandering into tangents that created additional legal exposure. His performance under oath has been consistently terrible across every proceeding where he has been forced to participate. There is an irony here that borders on poetic. Michael Cohen, of all people, demonstrated the blueprint for how to handle Trump in litigation. Cohen was sued by Trump several years ago in a case that has largely been forgotten amid the flood of legal battles that followed. Cohen did not file motions to dismiss. He did not try to win on procedural grounds. He simply asked for Trump's deposition. Trump refused. Cohen went to the federal judge and demanded it. The judge ordered Trump to appear. Trump requested an extension, claiming scheduling conflicts. The judge granted it reluctantly and set a new date. Cohen scheduled the deposition again. The day before it was supposed to occur, Trump announced he would not appear. The judge granted one final extension with an explicit warning. If you miss the next scheduled deposition, your case will be dismissed. Trump waited until hours before the deposition was set to begin, with Cohen's legal team fully prepared and waiting. He did not show up. The judge dismissed the case. That dismissal was without prejudice, meaning Trump technically retained the ability to refile the claims. But he never did. He could not. The price of pursuing the case was submitting to a deposition, and that was a price Trump was unwilling to pay. He chose to abandon his own lawsuit rather than sit for questioning under oath. This is the roadmap for anyone who genuinely wants to defeat Trump in litigation. Do not try to win on the pleadings. Do not give him the procedural exit that a motion to dismiss provides. Force him into discovery. Demand his deposition. Watch him either submit to questioning that will expose him or abandon his case to avoid it. The Wall Street Journal case is even stronger from the defendant's perspective than the Cohen case was. Trump is the plaintiff here. He chose to file this lawsuit. He chose to put his relationship with Epstein at issue. He cannot credibly argue that his own testimony about the subject matter of his own complaint is irrelevant or unduly burdensome. The deposition is absolutely essential to the defense, and Trump has no possibility of resisting it through legal objections. He must appear. He must testify. He must answer questions about Epstein under penalty of perjury, or he must dismiss his own case and slink away in defeat. The judge has actually done Trump an enormous favor by dismissing the initial complaint with leave to amend, but Trump appears too consumed by his own impulse for combat to recognize the gift he has been given. He filed this lawsuit immediately after the Wall Street Journal published its report. Typical Trump behavior, something embarrassing emerges, and his reflex is to attack. He calls it a lie. He sues for defamation. He doubles down with the kind of absolute denial that leaves no room for retreat. It was only after he committed to this position that the Epstein estate produced additional evidence, the actual 50th birthday book with its pages intact, including Trump's contribution positioned right where it should be among the other birthday greetings. Ghislaine Maxwell had collected these pages and preserved them. Handwriting analysis has been conducted. The evidence that Trump wrote this birthday message is overwhelming, the kind of documentary proof that would be devastating at trial. The fundamental problem with Trump's case is not some technical pleading deficiency that can be cured by inserting different language in an amended complaint. The fundamental problem is that his entire lawsuit depends on proving the birthday card was fabricated, and every piece of available evidence indicates that it is genuine and that he wrote it. He is the plaintiff bearing the burden of proof. He must demonstrate that the Wall Street Journal published false information about him, knowing it was false or with reckless disregard for its truth. He cannot possibly meet this burden. The truth is that the document exists. It appears to have been written by him, and any thorough examination of the facts will only strengthen that conclusion. The Wall Street Journal was smart in how they presented the story. They phrased their reporting carefully, not quite asserting definitively that Trump personally drew the birthday message, but presenting the evidence in a way that allowed readers to reach their own conclusions. This editorial sophistication provides additional layers of legal protection. Even if Trump could somehow prove the document was not authentic, which he cannot, he would still face the challenge of demonstrating that the journal's reporting was knowingly false rather than simply based on evidence that appeared credible at the time. So the judge gives Trump an exit ramp. The complaint is dismissed. He could walk away. He could claim victory, spin the dismissal as a vindication, tell his supporters that the court recognized the weakness of the journal's position. He could accept the procedural defeat as a strategic win and move on to other battles. But Trump does not know the rule of holes. When you find yourself in one, stop digging. Instead, he announces that he will refile. He will amend his complaint. He will fix whatever the judge said was missing and press forward with the case. He will dig himself deeper into a hole from which there is no escape except through a deposition that will expose everything he has spent years trying to keep hidden. The amended complaint is child's play to draft. Trump's new lawyers, a Florida firm apparently assembled for this specific matter, simply need to insert a paragraph alleging that the Wall Street Journal acted with actual malice, that they knew the information was false or were recklessly indifferent to its truth. These are magic words that satisfy the pleading requirement without changing anything about the underlying reality of the case. But inserting those words means the case survives the motion to dismiss stage. It means discovery begins begins. It means Trump must sit for his deposition. There is no procedural mechanism that allows a plaintiff to avoid being deposed in his own case about matters he himself placed at issue. The deposition would be politically toxic beyond anything Trump has faced. This is not about financial fraud or hush money payments or even election interference. This is about his relationship with Jeffrey Epstein, a name that evokes revulsion across the entire political spectrum. The questioning would cover the so-called bromance, the wingman relationship, the years of socializing and partying together. It would explore every documented interaction, every photograph, every flight manifest, every witness account. It would force Trump to explain, under oath, the nature of his connection to a man whose crimes shocked the conscience of the world. The complaint itself makes this inevitable. By attaching that footnote listing articles that followed the Wall Street Journal's lead and published their own allegations about Trump and Epstein, his lawyers have handed the defense a ready-made outline for the deposition. Each article becomes a line of questioning. Each allegation becomes a subject for sworn testimony. The deposition would proceed from one article to the next, hour after hour, with Trump forced to address every embarrassing detail that has ever been reported about his association with Epstein. There is no way to spin this. There is no way to deflect it. There is no way to make it go away except by dismissing the lawsuit entirely. Trump's instinct to attack, to deny, to sue has served him in many contexts over many years. But here, it has led him directly into a situation where his only options are catastrophic testimony or humiliating retreat. The deposition would expose him to perjury charges if he lies. It would expose him to public outrage if he tells the truth. It would expose him to endless political attack ads featuring his own sworn words. The alternative is to dismiss the case he so boldly announced he would refile, admitting through his actions that he cannot face questioning about Epstein. The judge's dismissal was not just a procedural ruling on pleading standards. It was the first step in a process that could force Trump to confront the very subjects he has spent his entire political career trying to avoid. The court has given him a chance to escape with minimal damage. He appears determined to reject that chance and barrel forward into disaster. The rule of holes applies with special force to litigants who sue over matters they would prefer never to discuss under oath. Every step Trump takes deeper into this litigation is a step closer to the deposition that could define his legacy in the darkest possible terms.